Hello, good afternoon. Going to be admitting people as we go along here, but it's a minute after 4 o'clock or so today. And thanks again for joining us, everybody that's here. It's nice to see smiling faces. Another Tuesday afternoon. As you all know, this week, our first presentation is by an important person. You know Steve Danyew's music. He's a prolific composer of all genres, chamber music, choral music, wind band music that we all know right now and appreciate. You may or may not know that Steve and I go back a little ways. We were both students at the University of Miami at the same time where I first met Steve. Steve finished at Miami and went on to do a master's degree in composition at the Eastman School of Music, where he now serves among the faculty at the, I think it's called Institute for Leadership at the Eastman School, where he teaches about music entrepreneurship and the business of a music career. He is an author as well as a composer, and I'm really grateful that he's made time to spend with us today, as I'm sure you all are. So we'll do a silent Zoom mute round of applause and welcome Steve. Thanks for being here, and we look forward to this time with you.
Thanks. I just tried to share my screen. It says host has disabled screen sharing.
Oh no, well, and I forgot some of my preamble. Let me see. I need to remind everybody that if they, let me see, how many participants can share at the same time? It says some can, but let's change that. Who can share? Oh, let's do this. All. Does that change something, Steve?
Yep.
Okay. But that helps too. I did forget part of my preamble is those of you Arkansas colleagues looking for professional development hours, please comment in the chat that your name, your school, and your email address. Lots of us are already doing this. Beautiful. That way I can get this list to the important folks to get your certificate. If you have a question under participants in the bottom of your screen, there's a nice happy number 40. There's 40 of us, 41 now. You can raise your hand if you'd like to ask a question, and I will try to monitor that. If I miss it and you want to unmute yourself and jump on in, Steve's the nicest guy you ever met. So jump on in, and I'm sure he'd be welcome. He'd welcome your question. So, sorry, Steve. Now we've shared screen. Here we go.
All right, great. Thanks so much for the invitation today, and welcome to you all. And certainly, thanks for having me here with you. So we're going to talk about copyright for musicians and some tips for online teaching, which of course in today's climate is, I think, something we're all dealing with. So I'd like to start with this little disclaimer about copyright. I'm not an attorney, I'm a composer. Those are very different things. This is not official legal advice, for specific copyright scenarios. Certainly you're going to want to consult an attorney. A quick overview of what I'm going to talk about, a little background on copyright. What is copyright? Why do we have this? Some of the important details. We'll talk about fair use, because fair use is certainly, I think, where a lot of the educational related questions come up. And it's a topic that I think is a little misunderstood. Then we'll go through some frequently asked questions that I think apply in education. And we're going to do some of these as polls. So you'll see a poll pop up on your screen. You select an answer, and they're anonymous, so do not worry about us knowing what you said. It's just a way for us to kind of get a feel for where's everyone at on some of these questions. And then again, we'll talk about some tips for teaching online. So Dan, if you'd launch the first poll, just to kind of see a baseline of how confident you feel in your copyright knowledge and how it relates to your work. Curious what you all think here. So we'll just give you a few moments to submit an answer. Again, this is anonymous, so we're not going to see a name or anything.
29 out of 42 responders. 31.
Thank you all for indulging my use of polls here.
31 brave responders.
Yeah, yeah.
Ending poll now.
So let's see. Survey says
Share results. Nobody.
moderate. Okay,
Nobody.
good. So
Very.
no one feels very confident. A lot of people feel moderately confident, and some people are not very confident. So good. I hope that what we talk about here, is helpful and kind of moves you up that list a little bit. So let's talk a bit about intellectual property, because that's where copyright really comes in. We all know how to protect a car or a home, right? But how do you protect property that's not physical, that's intellectual, created by the mind? Music, art, how do you protect those things from being stolen or used in some way? And copyright is one of the three protections that we have for intellectual property. The other two are trademark and patent. So copyright protects original works of authorship, and we'll look at what those are in a minute. Trademark protects words, phrases, logos. So think the Nike swoosh and just do it. Those things are going to be trademarked to protect those. And patents are used to protect inventions. So when a new medicine is developed, patent is going to be applied for that. So again, we're going to focus on copyright here because that's where music falls. Original works of authorship, that includes things like books, movies, even computer software, the language on websites, anything that can be authored can be protected by copyright. So what exactly is copyright then? It's what's often referred to as a bundle of rights or a set of exclusive rights that helps protect that work. And so some of the rights that the copyright holder gets when they create a work are the right to reproduce the work, distribute the work, display the work. That's more for visual art, of course. They have the exclusive right to prepare derivative works. This is something we're going to talk a little bit more about because certainly in music, this is a big topic, right? Making arrangements, transcriptions, that's an exclusive right of the copyright holder. The copyright holder also has the right to make recordings of the work and perform the work in public. Now, these rights can be assigned to other people. They can be licensed so that we can use the work in different ways. But in the beginning, the copyright holder really kind of holds all the cards. So copyright was really created for the benefit of the public. In 1790, the Copyright Act, the founding fathers wrote this, to promote the progress of science and useful arts. So they were offering protection to creators in the idea that that would incentivize them to create. If I can't protect my compositions in any way and anyone can use it and sell it and gain from it, I'm not going to be incentivized to create, right? And the public is not going to then benefit from all of the art that's going to be created. So it was very, very keen of them to recognize that they needed to offer protection so that the public could have art in the future. So let's consider a little bit what can be copyrighted within music and without, outside of music as well. An important point is that ideas themselves are not copyrightable. So, you have this great idea in your head, that's actually not copyrightable. What is copyrightable is an expression of that idea. And so what I mean by that, for example, you can't copyright the idea of minimalism, the idea of, using a very small cell of music and creating a whole piece out of it. But you can copyright your expression of that idea, your piece. Let's say it's called Cycle and Cycles. And in order to copyright something, it really just needs to be original, so not stolen from someone else, and it needs to be fixed in some kind of tangible form. So it needs to be written down or saved on a hard drive or recorded on some kind of tangible medium. If we, for example, just improvise something and it's never recorded, it's never captured, we can't copyright that. If you capture it somehow, we can copyright that. Okay, the second kind of fundamental point I want to make about copyrighted music is that there's two distinct copyrights that we deal with. So you see the picture of the record here. Within a recording, there's two distinct things. There's a sound recording and there's a musical composition. And we have two separate copyrights for these things, two copyrights embedded in one recording. So let me give you an example of what this looks like from my own work. So I have a composition called Magnolia Star. I'm the publisher for that piece. I own the copyright to this work. A few years ago, the University of North Texas Wind Symphony recorded Magnolia Star on this CD you see, Pathways, on GIA. They needed to get a license from me in order to include my composition on the recording. But the actual sound recording that they made in that studio, they own that sound recording. I don't have any rights to that recording. I have the rights to my composition. They have the rights to the recording. Two separate copyrights. And I mention that because it's important to know how that plays out when we go to get permission for using copyrighted work. So if someone wants to use my composition for something, make an arrangement, make a recording, any number of things, they get permission from the owner of the copyright, the publisher in most cases, which is me. But if someone wants to use the sound recording of Magnolia Star from this Pathway CD, they need permission from both the recording copyright holder, which is likely GIA in this case, and myself. Because if you're using the sound recording, you're using both those sounds and the composition. So what parts of music are copyrightable? Certainly complete works, songs, compositions, you're going to be able to copyright that. Can you copyright a melody? Possibly. If it's unique enough, yeah, you'll be able to copyright that. This is a question that comes up a lot today. A beat, a groove, can you copyright that? It's possible. Yeah, again, it has to be unique enough where we can't compare it to something that's been written before in history and say, look, you used this is the same, so it's not original, it's not copyrightable. But if it is original enough, yeah, it probably is. And you see the way that I'm talking about these things, probably, maybe, and that's because there's no, in the law, there's nothing that says, yes, harmony can be copyrighted, no, a beat can't, yes, this many notes or this many chords. It's really kind of flexible. And so we have to think about each scenario individually. Harmony is on this list probably the least copyrightable. There are cases where copyright has been granted to a harmony, a harmonic progression, but typically it's not, because in music we have these conventions of harmonies that proceed from certain chords to other chords, and even when we do something that we think is really interesting and unique, chances are something very similar has been done before, and so it's typically not as copyrightable.
Steve, can I ask a question?
Yeah.
Maybe it segues into this copyright gray area just very well. Maybe it doesn't. I'm dating myself, but I remember that Vanilla Ice had to stand up for this in regard to the Bowie Under Pressure.
Mm-hmm.
I can't remember how that played out. Did he have to pay Bowie for that? I mean, there's one note difference.
Yeah, my recollection of that case is that it was deemed copyright infringement. So it was like you're saying, it was so similar. It was essentially a baseline, but it was the baseline was and sort of the motive. It was such an integral part of the music, right? In really the original and the Vanilla Ice version, that's one of the things you look at is how substantial, using or borrowing was this. It's so substantial to those two pieces that it's like, this might as well be the same thing.
I got to make 3 points. Steve Danyew just called Ice Ice Baby a piece. Got a tip of the hat to Ralph Brody for that great comment, and point out that Vanilla Ice also went to Miami, just like Steve and I. So, yeah.
So yeah, that is a good segue into the copyright gray area. Like I said, there's no law that says, it's not copyrightable unless it's 6 measures or 10 measures, or the other way, like you can use up to this many measures in your own, adaptations. It's really not that specific. So I want to launch another poll here and see, what do you think? Is this copyrightable, this motive here? And I'm sorry there's not more answers than yes or no, but that's all we have.
Said it was gray, but we got 2 choices.
Yeah.
Okay, we have 30 responses. Steve, what do you think?
That's good. Yeah. Let's see what the responses are here.
31 response. What one person thought about it a long time. 32. Right under the gun. Share.
Okay. So most people say no, and a few yes. So again, there's not a right or wrong answer here. We could debate this. My answer is that this is likely not copyrightable because, number one, it's so short, right? It's 3 quarter notes. It's 2 notes. We're going to be able to look back in music history and see lots of examples of, bum, bum, bum. And we're going to be able to say, listen, this has been done by X number of artists. You can't really copyright this. It's not original enough. So again, gray area, but I think this is not copyrightable. So what is the length of copyright? Right now, and this has changed over time, the length of copyright is the life of the author plus 70 years. So when the creator of this work passes away, another 70 years until that work is no longer under copyright and then can be freely used by anyone without permission. And that, just allows a copyright holder's family to benefit from the copyright after they're passed away. So I'm not going to go through this table. Don't get nervous. There's a lot of information here, but just to show you that this kind of thing is out there, and I've pointed to some resources in a document that's going to be available after the presentation, where you can look up, if something was published in the US in 1954, is it likely under copyright or not, considering how long copyright term was at that time? During the 20th century, the copyright term changed significantly. So now it's as long as it ever has been, but earlier in the 20th century, it was shorter. So it's complicated for sure. So I mentioned there when a work is no longer protected by copyright, it falls into what's called the public domain, which I'm sure you've heard of. Works in the public domain can be used freely by anyone. You don't need permission. You can make arrangements, you can record them, you can do all kinds of things with the work. And again, you don't need permission. So a work enters the public domain because the copyright expires, like we just talked about, after that copyright term is over. An older work in the mid 20th century, when works needed to be renewed for copyright, there's some works that weren't renewed, and so they're in the public domain. And anything at this point that was published in the US before 1925 is likely in the public domain. And I say published, that's an important word because it's not necessarily when it was written or created, it's when it was published and made available to the public. Okay, switching gears a little bit here to talk more about infringement and fair use. Copyright infringement is when someone exercises any of those exclusive rights of the copyright holder without their permission. And, infringement can have pretty serious legal ramifications, significant fines if, the court deems that that's necessary. Lots of copyright infringement cases are settled before, going to a trial, but, attorney fees, all those things, the money is really significant. So that sort of, begs the question, when do you need permission to use a copyrighted work? And, what I tell my students, my biggest takeaway for this kind of thing is when in doubt, seek permission. So just try to remember that saying. Whenever there's a question like maybe we might need permission for this, when in doubt, just seek permission. It's the right thing to do. So I'll quickly run through, all the scenarios where we need permissions. If you want to perform a copyrighted work, you need a performance license. Fortunately, that's often in place already through the presenter or venue where you're performing, but that is needed. If you want to arrange a copyrighted work, you need permission to arrange that work. There's a permission to arrange form that's been put together by the Music Publishers Association. There'll be a link to that in my resources document. So again, not particularly challenging, but you want to plan ahead because, reaching out to a publisher, they could take time to get back to you. You want to leave plenty of time to get a response. If you want to record a copyrighted work, you need a mechanical license to do that recording. If you want to use poetry in a work, if you want to display images at a concert or on a website, all these things technically require permission from the copyright holder. And so, to me, usually the first step is reaching out to the publisher. They're usually going to be the copyright holder, or they'll know who you should contact. Okay, so I want to talk, like I said, a bit about fair use. And I've put up on the screen here those exclusive rights of the copyright holder for us to consider those one more time. And I highlighted this number 2 here, derivative works, because again, I think this is such a prominent exclusive right that is often foregone when we think about music scenarios and music and education sometimes. So fair use is this idea that there are certain uses of copyrighted works that you can do and it's okay even without getting permission. But it's very limited. So I think sometimes there's this idea that, oh, if we just use a little bit of something, it's fair use, or if we do this and this, it's fair use. But it's really a lot more complicated than that. There's this idea that if you give credit to the author or the creator, that then you're okay. That's not true. That's not fair use. Credit really doesn't really do anything. Just because something is educational, used in a school, used for educational purposes, that also does not automatically equate fair use. You could use something in an educational setting and it could still be infringing on someone's copyright. So this is what Congress has said about fair use, that there's these situations where, again, a work could be used without permission and it might be okay pending other situations that we're going to look at. So really the most common ones, the most common uses are use in like news reporting. So if you think of, you're watching the news and you see a reporter, they're at an event, and in the background there's logos, and in the background there's music. those things are, copyrighted, trademarked, right? But it's 10 seconds of footage and it's being used to report the news. That kind of use is going to be fair use. They don't need permission from the owners of that music to include it in their newsreel. You see teaching is listed here. So there are lots of situations where you can, use very small amounts of copyrighted work in teaching, and that's going to be fair use. But again, not always. Scholarship, research, these are situations where fair use can be applied.
Steve,
yeah.
Ken asks a question in the chat here in regard to costs for permission to arrange. Who sets those fees? Are you familiar with this at all?
Yeah, feel free to, after I give what I think, feel free to add to it, because I'm sure you know as much about this as I do. It depends on how you do it. If you go directly to the publisher, there's no government set amount, right? They're going to be able to say what they feel is appropriate, and they may have some standard rates. Or again, if the work is more prominent, the more prominent the work, probably the higher the cost is going to be. So you can go directly to the publisher. If you go through another kind of licensing organization, in education, of course, Tresona is a big one. They're going to have, again, their own set of rates that may differ from the publisher themselves. So that's a long answer. The short answer is it really varies depending on the work and the publisher and the licensing organization.
Yeah. I think I'll chime in just a little bit, but encourage everybody to unmute themselves and contribute here as they would like. I think the short answer I would give is that it's the same reason anything's the price it is. It's just what the market will bear. I recall years ago I arranged a Beatles show because I got kind of an itch in June one summer, and I thought it'd be fun to do a Beatles show. And then I wrote in and was told it'd be an ungodly fee. And I'd written some medleys. I mean, I had 9 tunes in 3 movements of a marching band show, and it was going to be $5,400 for permission to arrange. When I spoke to some people on the inside, I found out that a prominent publisher was about to release for mass distribution Beatles shows. So they were really trying to clear the field the year before. So they made the permission to arrange fees particularly punishing in order to create some demand for Beatles shows in the next few years. So it's business, and I think it's what the market will bear. Ken mentioned Tresona. They're the big sort of clearinghouse right now, but I hope directors will remember that they can go directly to Harry Fox. In many cases, they can go directly to Hal Leonard, and they can go directly to composers. I've had composer friends of mine. Recently, a composer friend of mine called me and said, the Blue Devils want to use a piece of mine. What should I charge them? And honestly, I didn't know how to advise him either. And he was, he said, I don't want to be a fool and undervalue my own work, but I don't want to be silly either. And I honestly don't know where that ended up, but I think it's the same as the price of milk. It's what the market will bear. Ken.
It really, my comment makes no point other than getting it off my chest, I guess. But
no, it's a great question. It's a great question.
In some cases, when you're doing like pop tunes or rock songs, it's very difficult to find out who owns. So that's why Tresona, I guess they have, people back there working on that, on who owns what. And of course, they're the middleman. So they've got to make some money. I get that. But it's not, and a lot of the people who are writing shows now, that's your job. They don't want to go to all that trouble to get the rights. So they put that on you. If you buy their show, then you have to go then and get the rights to do it. So
yeah, my understanding is that Harry Fox basically owns 95% of anything you'd ever want. The bottom line is the Foo Fighters, Dave Grohl doesn't want to bother with marching bands.
right.
He's not going to be interested in it. They have complex agreements with lawyers, and when it comes to things like this and that, it's just over there. And as it was explained to me now many years ago, so this could be long history, but Paul Lavender explained to me that the way Hal Leonard did it was they wrote a big check to the Harry Fox company every year to be sole avenue for school ensemble use, and that was show choir and marching band and concert band and all that stuff that you see in the J.W. Pepper catalog. And to those guys in LA that deal with real dollar signs, it wasn't a lot of money, but to the rest of us it is. And so when in doubt, Hal Leonard owns it. They have a deal with Tresona recently. Now things with Tresona have been tumultuous recently. And I think so the short-term future with what happens with Tresona will be interesting after a recent court case. But that's my experience with it.
Okay, so if I can ask one more dumb question and then I'm done. Is Harry Fox a person or a company or both?
Agency. It's an agency that you said that, there's middlemen here. My understanding, which again is limited, and I hope I'm just not dead wrong here, but as I understand it, the Dave Grohl and Foo Fighters have lawyers that deal with some folks in Los Angeles. And then those folks in Los Angeles are the people that deal with Hal Leonard. And if you Google up Harry Fox Agency, my friend Randy Foster, who's Bob Foster's son, by the way, the old director of bands at the University of Kansas. Randy founded, and boy, Steve and I didn't plan this, but another Miami alum, by the way. And Randy founded the Wind Band Classics series on Naxos when he worked at Naxos Records for many years. So all those wind band recordings were a part of Randy's brainchild. And Randy now, he left Naxos and he lives in Nashville working in music licensing and copyright and for the real world. So when somebody wants to use Like a Rock for a Chevy truck commercial, they've got to go through all of this. And Randy's one of the guys that makes that stuff happen. And that's Harry Fox Agency in California. All right, so Steve, I'm sorry, we might have gone a little off the railroad tracks there.
No problem.
Bring us back around.
Just Ken, to follow up about what you're saying about finding out who owns things. There are a couple of websites I'd point you to if you want to find that, which should be actually easier than maybe you think. ASCAP and BMI both have repertory lists that you can easily search. So you can search, Living on a Prayer. It'll come up and show you who owns that.
Right.
So that is possible. But of course, yeah, it's work that, you may not want to do. And sometimes things are hard to find. But just to point you to those resources. And, a new law, the Music Modernization Act, was just passed. And that one of the things in that is that there's going to be a new central clearinghouse where you can search all works to find these things out. So, look for that in the coming, who knows how long, but that is an improvement that they're working on.
One more question before we let you get rolling back on your bullet points, Steve. Charity asks a question very common in what we do. She says maybe this will be addressed before the end of the presentation. So again, please let us know, Steve, if that's the case. But she asks about recordings at concert band events. She says specifically all region and all state. When they record the groups and then they sell those recordings back to moms and dads. Yeah, Ken's making kind of a funny hush signal over his mouth there. What I'll say is what I understand should happen, and I believe does in most cases. These days, everything gets so much sunlight. The internet makes things so public, no matter what anymore, that it's also just not, my understanding, not even remotely worth it to even take the risk anymore. What should happen is the folks that are making the recordings need to apply. When Steve mentioned earlier that someone would need to reach out to North Texas about using the Pathways recording, that's called a mechanical license to record. And then there are versions of that where you ask for permission to use it and then sell that product. So the recording company should be going through the work. That's what we do at our Concert Band Festival, at our affiliate regional Concert Band Festival. We actually stopped, if you'll notice, we stopped selling recordings because we realized that this was going to be a little bit more than the turnaround was going to be. That we needed to get all the repertoire and then clear all of that professionally and thoroughly in order to have permissions to sell the recording. So Music for All is selling many fewer recordings than they ever had before. There was a big court case that I understand involved some prominent composers years ago. And at our event, we don't sell recordings for that reason. Steve or anyone?
Yeah, just to piggyback, that's essentially right. When a piece is recorded, you need a mechanical license. So like in Allstate, the company that's recording that is going to reach out to Harry Fox. Harry Fox is essentially the company that does mechanical licensing. And they're going to pay for a mechanical licensing based on the number of copies that they're producing. And then that money will get distributed to the copyright holders of those works. So yeah, that's the right way to do it. I think that, I see that happening. So I'm confident that people are doing that. Cool. So yeah, feel free if there's other questions, stop me again. Just touching on fair use, one more item here. These are the factors that the courts are going to consider in terms of determining, is your use of this copyrighted material fair or not? So again, just to elaborate a little bit on how this is determined. So there's 4 factors. Number 1, whether the work is for a commercial purpose to make money, or if it's a nonprofit, educational use. If it's a more commercial kind of use that you're doing, of course, that's going to be less fair use. The second, the nature of the copyrighted work, whether it's more creative or maybe a more factual kind of work that you're using in some way. The third is a big one, the amount of the work that you're using. So are you using 5% of a song, or are you using most of the song, or are you using a small piece, but it's really, like we talked about with the Vanilla Ice example, it's like the main piece of the work, the most important piece. That's the substantiality of it. And then the fourth factor is, does your use affect the market for the original work? So can people just come and buy or experience your new version and it affects the market of the original? If that's the case, probably not fair use. But if your use doesn't affect the market of the original, that's going to weigh more towards fair use. So
let's again a little bit there, Steve, as well. On the chat, that we've taken the next step here in regard to liability. In the iPhone era, mom and dad make a recording and they put it on their Facebook, or they put it on Baby Hercules' Greatest Hits YouTube channel. Who's responsible?
Yeah, so that is a question that comes up all the time, of course. And really the law is that, if you make a recording of something, for public and you're going to post it somewhere, you need a license. Now, we know that is not always followed. We know on YouTube that things are uploaded every day that do not have licenses. And YouTube has, programs in place where they try to then match that content to the copyright holder, let that copyright holder monetize those videos to try to, sort of make it right in some way. But, if we really look at the bare bones facts, yeah, if you're recording something, you're uploading it to Facebook, YouTube, technically you need a license for that.
I know of one situation that I was not involved in, and I heard all of the information secondhand. So please keep that in mind. But was a marching band that had not gotten permission. Worse yet, had applied for permission and was denied, but then went ahead anyway, and then posted the performances on YouTube. And this was 15 years ago or so, and even then, that was kind of so egregious that there was some pursuing happening there. They'd gotten on the radar screen by asking permission, and were told no, and they did it anyway. And then they hosted the YouTube video on the main page of their band website. I think it is not legal. If Mom and Pop Jones make a recording of your show and they put it on YouTube, it's just technically not legal. I believe it is such small impact that I imagine, okay, this is not an expert opinion here, but my understanding is that there would very likely be a request to take it down long before there was anything too punitive that would happen, and people would have to be pretty belligerent before things got too out of hand. I mean, most of our folks are having a circle of influence of a few hundred people, and this isn't going to change the lives of people in a real significant way. Something that is, I think, very significant. Ken has asked a terrific question, Steve, that I think you've experienced as well, and is very common. We hear directors say, "Listen, I want to pass out photocopies. I own the piece. I bought it. It's in the library, so now I'm in good graces." You see the cat is visiting me, everybody. But I want to keep the originals in the library. Can I pass out photocopies?
Yeah, so technically, again, the answer there is no. There's very limited cases where you can photocopy music and distribute it to an ensemble. That's one of the frequently asked questions we're going to get to, but in essence, yeah. The only really acceptable times when you can photocopy a piece of music are like in an emergency situation where you need it to perform, you have an imminent performance and there's no other way. You can photocopy a part, for that. You can photocopy a very small amount, just like we're looking at here in fair use. In music, they say 10% of a performable, of a work, it can't be a performable unit. So it can't be a movement, it can't be a full section. So it's very, very limited. But like that particular scenario, yeah, again, just looking at the law, you can't do that.
Yeah, I've got two sets of experience with this. I mean, the most common are just straight traditional, published by Ludwig, Lincolnshire Posey set. As some friends at, again, Paul at Hal Leonard explained to me, is the price point on that set of the first suite in E flat is not set so that George Washington High School buys it in 1955 and never has to purchase a set of the first suite again for 1,000 years. If that were the idea, the price point for that set would be much, much higher than it is. They're set with the concept of paper being disposable, and that parts will be lost, and that another set will have to be purchased in some reasonable amount of time. On the other hand, Steve is one of these more modern composers. Ryan George comes to mind, who these days, when you purchase music, will send you a site license. And it's a very specific agreement where Ryan will tell you, print out all you want. I'm sending you digital files, and for this campus and this ensemble only. Yeah. But just go ahead and print all you want. You never got a set of parts from me with the full understanding that you were going to just go print them out.
Yeah, I think a lot of self-published composers are doing that now, sending you digital files, but exactly specifying it's for this particular school or for this particular use, and other uses, do not apply here. So you can't share it with another ensemble, or, bring it to an all state. All those kinds of things, are separate. Yeah, great questions though. Absolutely.
Is that time for poll question number 3, you think, Steve?
Yeah, so let's enter back into our gray areas here and look at a few more questions. So first one here, can you photocopy an entire textbook, or if we translate that to music, an entire piece of music to distribute in classroom teaching? We kind of just talked about this, so we'll see what the response is. Should be a pretty easy one.
How many Cokes in a 6-pack? Oh.
How many responses you got there?
We got 33.
That's good. Yeah.
34, 3, 2, 1. We got 1 yes.
All right. So yes, 97% of you would be right. Again, thinking about the fair use, those 4 factors, the third factor is the amount of the work. It has to be a small amount to be considered fair use. And again, there's those 3 other factors. That's only one of the factors, is the amount of the work. But an entire work of authorship, there's no way that's going to be considered fair use. Let's consider a related example. So let's say you are going to use a small excerpt from a book, or a small excerpt from a piece of music in your classroom teaching. Is that going to be okay?
Right. I forgot to ask for permission to use the Jeopardy theme.
So we can go ahead and see the
31 responses, 33 responses. Some people are really thinking on this one. We got some people afraid to jump in the pool. 34, 3, 2, 1.
Yeah, so 79% yes. This is, again, it was a little vague. And so I appreciate that some people chose no, because, I was not specific here in terms of how much, I'm talking about how much of it we're using. So I think in general that a small excerpt for use in teaching in an educational setting is usually going to be okay. But again, it's a slippery slope. How small is that? That's where we get into the gray area. Okay, next question. Can you rearrange a piece of music you're performing? Add a whole bunch of things. Add new voice parts to a work that doesn't have voice parts. Change the ending. Make some really substantial changes. Can you do that?
Might be my favorite question of the bunch.
All right, how many responses do we have?
32.
All right, let's see it. Okay, yeah, so most people think no. Again, significant changes to a copyrighted work, that's going to push this into a derivative work. And that's one of the rights of the copyright holder. So, when you're essentially making an arrangement, you're making significant enough changes that it really falls into the idea of an arrangement or derivative work. You're going to need permission for that. That's something you can't just do without permission. So again, related example, can you just modify, trumpet 1 part because it's too high for the players that you have in the group this year? can you do that without permission? What do you think?
Most of the trumpet players in my life have modified the part without my permission.
Modified it up an octave?
Just every direction imaginable. 34 responses.
All right, let's see them.
35.
Yeah, good. So making small changes that don't affect, the entire work, that's going to be okay. That's written into the law, that in education you're going to be able to make those really small changes and you're fine. But again, just be careful that it doesn't become significant enough changes that it becomes an arrangement when you need permission. Okay, we talked about this one. Can you use copyrighted music in your marching band show without permission? You want to use a piece by me, or you want to use a piece by Ryan George, or you want to use Beatles or Michael Jackson. Can you just, put that into your show?
Question might need to be more specific. Can you do it without breaking copyright law?
Right. Can you do it without permission? Is that
because can you do it?
Oh, right. Yeah.
Yes. I mean, we've seen it for decades.
Yeah. Yeah.
It's a sharp bunch in here.
All right. Good. Yeah. So yeah, you need permission to do something like that. Especially, if it's going to be any significant amount of material. Okay, we kind of touched on this one too. Can I record my concert, which includes copyrighted work, and post it online to YouTube, let's say? Is that okay to do without violating any copyright laws?
I think is a fascinating question that's out there these days, is if the Chicago Symphony Orchestra records copyrighted music, in the law there is one recording that is allowed for archival use. Am I correct there so far, Steve?
Right, yeah.
So as I understand it, however, there's some debate. There are 90 players perhaps playing that Mahler. Do the individual performers get an archival recording each, or just the Institute of the Chicago Symphony Orchestra?
Yeah, I think it's written as it's just the Institute. So it's the same with a school. You can record your concert and make one copy for archive at your school, for you to have there and review for the future, whatever, but it's not distributing it to the people in the ensemble.
I think this is really something to drill down on a bit, so we can't make a recording of the concert and give a free CD to all the players in the group. Unless
you've gotten those mechanical licenses in place through, Harry Fox, or going to the publishers, getting permission to record and distribute. Because what you're really just doing at that point is distributing the recording. And so you need a license so that the copyright holder of those works, they're paid a royalty for each of those copies.
I'll remind everybody, this isn't Steve's fault. Don't get mad at Steve.
Yeah, I mean, some of these things, as much as they seem like this is a pain, or this is like the photocopying music, it's just the law, and I'm not setting them, but that's just what it is.
When I was at Illinois State building the state marching band championship there, we put in some stronger guidelines to try to protect copywritten music. We had not been ensuring that bands had permissions to arrange the marching band shows. And legendary band director Ken Snook was one of our advisors, and he was the person that came to me first and said, we've got to start doing this. And I said, Ken, I don't know, man. The band directors are going to get hurt. I don't know how this is going to go over. And I'll remember till the day I die what he said to me. He said, Dan, if band directors aren't willing to fight for the intellectual property of composers, who is? Just bottom line. Yeah. If we don't think that music is worth something, using it has some value, and that value should be shared with its creator, then what are we doing? So it's a complex issue right now. And in some cases, the costs of the permission to arrange have gotten very, very high. And some of that money, maybe very little of that money, is going to the composer. And that's an issue certainly to be dealt with. But I'll never forget what Ken said to me. I thought he was 100% right when we made that change. And frankly, we really didn't get any pushback from the directors at all. The band directors understood in Illinois that that's the way it needed to be.
Yeah. All right. So yeah, you all were pretty much correct there. You can't just upload things to YouTube without permission. Okay. Final frequently asked question. Does a copyright holder need to file for a copyright with the Copyright Office, with the government, in order to receive copyright protection? And we haven't really talked about this. So this is a sort of bonus question here.
Gotta say too, I see your background there, Ken Williams. Classy, coordinated with the top. I see it. All right, 33 responses.
All right.
Going 3, 34, 2, 1.
So again, this question is a little admittedly vague, but in order to receive copyright protection, a creator, the work needs to be original, and it needs to be fixed in tangible form. Once something is fixed in tangible form, it's technically protected by copyright. So I could scribble down a melody on a notepad right now, and at that moment, it's fixed in tangible form, it's original, it's protected by copyright. So you don't actually need to file and receive a copyright from the government in order to receive protection. I certainly recommend that people do that. And there's a few reasons, why when you get into copyright infringement cases, you need to have that official copyright. But for it to technically be protected by copyright, you don't need that. So,
Steve, I can't believe it, but it's already 2 minutes till the hour here.
Yep.
Can we find our way to a stopping point?
Yeah. Do you want me to? I can run through. This is the end of the copyright stuff. I can run through a couple of online teaching tips, or we can forego that.
I'm sure a lot of people came for some of those. This copyright resources information that's on the screen now, everybody, there is a handout at atu.edu/bans under the educational resources link again. And Steve will be posting more information to the website later on for your perusal. But yeah, Steve, I'm sure some people would really like some of the online teaching stuff that you use all the time in your teaching.
Yeah, absolutely. I'll run through this quickly. I've been teaching classes online for a few years, and these are some things that I would humbly offer as things I've learned. So, this is a screenshot of my copyright course in Blackboard that we use at Eastman. And so you can see we use modules. So each week is a module. So this would be the second week of the class. And, activity 2.1, 2.2, 2.3, it's pretty organized, and there's different types of content in each module, but you want to have some organization that helps the students have that structure online. At the same time, we all know students need to be autonomous learners, so you want to give them some flexibility, give them some choices, have assignments where they can choose kind of the direction they want to go. Videos, keep them short. With something like this, a copyright talk that's an hour long, I would break it up into sections that would be 10 minutes each, let's say, and I might have 2 videos and then some other kind of activity, and then 2 videos and something else. Just best practice is to keep those things a little bit on the shorter side. And to use a variety of different content. So, video content, you could have audio, some readings, of articles, books. Have students go out and do research on, different things, different projects. Collaborate. We have a lot of tools now where students can, virtually collaborate. And then, of course, there's assessments that you can do, online of all different kinds. For videos, seeing you is engaging. So instead of just having, a presentation with audio, use tools like Loom, PowerPoint, Panopto, so that, or in Zoom like we are now, where you can see me and see what we're talking about. That's a better educational tool. This is a little thing, but I think it makes a big difference. Camera angle, if you have your computer or device, tablet on a desk, on a table, and it's sitting looking up at you, that's the screen on the left, not as ideal. On the right, it's propped up on some books or whatever you have. You want the camera to be like kind of at eye level. And if you do that, it's going to look more like, you had a professional camera crew come in and shoot your video. Another little thing, think about the background. Of course, with Zoom, we can have virtual backgrounds, but if you were just recording a video to share with your students, think about the background, right? You don't want, number one, anything that you don't want to share on a video in that background, and you don't want it to be too busy. You want the focus to be on you, so try to avoid anything that's going to take the attention away from you. Ideally, you want light coming in onto your face. So I have a window that's about 10 feet that way. Natural light on your face, that's kind of the ideal scenario if possible. An external microphone, if you're able to, is a great investment. I'm using a Blue Yeti right now. It's about $100. I use it for recording music, piano, saxophone, singing. I use it for things like this all the time. And it's just a little bit clearer, a little bit better than, your device microphone. And finally, give students some grace with technology issues. My students every semester I have issues with students, having trouble uploading something or recording something. There's some glitch, so just tell them to communicate with you immediately, right? So if they have a problem, get in touch and, just give them some patience, some grace. And so finally, I'll just mention a couple other resources. Eastman has this page here with online teaching resources that they put together for their faculty, but they encouraged me to share with you. So there's things here about how to use different tools, and these slides will be available to you, so you can get that link. And Eastman has a couple of programs. There's a certificate program. I have students in my class, my online classes. I have students from Eastman, and I have students from all over. I have music educators who teach college in the US and Canada that are taking the same exact classes for a certificate program. And that's something Eastman started a couple of years ago, and has copyright, music careers, music leadership, things like that. And then this Masters in Arts Leadership, Masters of Arts and Music Leadership program is a new program they have that's might be transitioning to be an online program. Right now it's not, but again, just something to mention here if you're interested in checking that out. That's it.
Thank you, Steve. I really, really appreciate it. I know everyone does here. Any last questions for Steve? Right now, there's his contact information. Please take it down. Again, I've known Steve for many years here now, and trust me, he'd be happy to hear from you as you continue to ponder these things. Some of these copyright things in particular are difficult, and they're sometimes counterintuitive. I know that we all want to do right by the law. We want to support composers and musicians and new music. And we want to do that in ways that also allows for us to operate inside of our programs effectively as well. And everybody that I've spoken to on the inside, so to speak, of all of that, they all agree as well. You know, every composer wants their music played, and every publisher wants the composers that they represent to be played as well. So in very rare cases have I had anything other than a really positive interaction when I've tried to reach out about what I need in my program in order to make something work. So I'm sure you will as well. And I know that Steve can be a good shepherd in all that if you can communicate with him more in the future. So if there's no other questions right now, everybody just keep that contact information. And Steve is going to give us some of these resources to post on that website. We posted the link again here in the chat to that, where you can access that in an archival kind of a sense. All right. Well, then again, thank you, Steve. Appreciate
My
you.
pleasure.
Good to see you.
Thank you.
Friend.